The laugh is what I remember most clearly. My husband's attorney let it out the moment I walked through the doors of the patent tribunal hearing room, without a single legal representative at my side. It was a sharp, dismissive sound. The kind of laugh designed to make every other person in the room look over and confirm what he already believed, that I was a joke. "She's representing herself," he said to my husband, loudly enough for the entire room to hear. "Sweetheart, do you actually understand what a patent tribunal is? This isn't small claims court." My husband leaned back in his leather chair and smiled. It was the same smile he'd worn for 6 years of marriage, confident, certain, completely untouchable. The presiding examiner adjusted his reading glasses and looked down at the case file in front of him. The room went very quiet as he turned to the first page, and then he stopped. He looked up. He looked directly at my husband's attorney, and he said in a measured, completely flat voice, "Counselor, did you read the full inventor disclosure on this patent before you filed this transfer?" I watched my husband's smile disappear in real time. "My name isn't important right now. What matters is this." For 6 years, my husband thought he'd married a woman who gave up her career to support his vision. He thought I was grateful. He thought I was small. He had absolutely no idea that he'd been sleeping next to one of the lead patent architects of the very technology he was now trying to steal. 6 years ago, I was 31 months into building a quiet but serious career as a licensed patent attorney and IP consultant for pharmaceutical startups. I worked under my maiden name, professionally invisible to anyone who only knew me as his wife. The work involved pending drug delivery patents that required confidentiality agreements, strict enough that keeping my professional life entirely separate from my personal one was genuinely the correct thing to do, not a choice I made lightly. I met my husband at a charity auction in Austin. He was handsome and certain of himself in a way that initially read as ambition. He was launching a biotech company focused on a novel drug delivery platform. He needed investors. He needed visibility. And I, who had spent 3 years quietly helping companies like his protect exactly that kind of intellectual property, found his work genuinely interesting. What I didn't realize until much later was that he didn't want a partner. He wanted an audience. We got married a year after we met. I scaled back my consulting work to give us both time to settle in, intending to return to it fully once things stabilized. But every time I started to, there was a reason not to. His pitch season, his funding rounds, the dinners I needed to attend, the image we needed to project. Slowly, the version of me that existed professionally got quieter and quieter inside our house, while the version of me that smiled at galas and remembered the names of his investors' wives got louder. He thought the professional version had disappeared entirely. She hadn't. She'd learned to work at 5 a.m. in a home office I told him was for budgeting and personal projects, connected to a separate email, a separate phone, and a separate professional identity that continued building quietly while he slept. The thing my husband never knew, the thing that eventually undid him completely, was that before we met, I had been one of 3 co-inventors on a core drug delivery mechanism that his company had licensed and built its entire platform around. The patent had been filed under my maiden name. His company's lawyers had negotiated the license directly with the IP firm I consulted for. And because my husband had never taken the time to actually read the foundational documents underlying his own company's technology, he had no idea that the name on page 3 of his most valuable asset was his wife. I'd kept that information private, not out of deception, but out of professional ethics. The consulting relationship predated our marriage, and maintaining clean separation was the right thing to do. I'd planned to tell him when the pending cases resolved. Then I found out he was selling the company. I didn't find out the normal way. I found out because his girlfriend left her laptop open on our kitchen counter. That sentence needs a moment to sit. His girlfriend, the woman he'd apparently been seeing for 7 months, A corporate IP attorney at a firm downtown. Young, polished, and absolutely convinced she was the smartest person in any room she entered. She'd been helping him structure the asset sale, using her legal access to quietly transfer the core patent portfolio to a shell entity before the sale closed, effectively cutting out the minority shareholders. The board, and, because of a deliberately vague amendment she drafted to the original license agreement, cutting out the original inventors entirely, including me. I didn't look through her laptop intentionally. I was looking for a charging cable. The document was just open on the screen. Patent transfer authorization. My patent number. Her firm's letterhead. My husband's signature at the bottom. I stood in my own kitchen for 3 full minutes without moving. Then I closed the laptop very carefully. I went upstairs, sat down at my 5 a.m. desk, and I called the senior IP consultant I'd worked under for 7 years. Pull our original inventor disclosure for the TX9 mechanism patent, I said. And get me everything filed in the last 90 days on any derivative license amendments. She asked me why. Because someone made a very significant mistake, I said. And I need to understand exactly how large it is before I decide what to do about it. The dinner happened 4 days later. My mother-in-law hosted it at her house, a sprawling property in the hill country outside Austin that she maintained with the particular intensity of someone who believes square footage is a moral virtue. She called it a family celebration. What it actually was, a victory lap. My husband had told her about the sale. He had not told her about me. He'd apparently already assured her I'd be signing off on the divorce quietly and quickly, because she greeted me at the door with a kind of formal, practiced sympathy that made the skin on my arms tighten. "You must be so overwhelmed," she said, taking my coat without asking. "Change is always hardest for people who aren't used to moving forward." My brother-in-law was already there, 2 drinks into the evening, sitting at the head of the dining room table, with the comfortable posture of someone who believes proximity to success makes him successful. He was the company's CFO. He knew about the transfer. He'd signed off on it. She was there too, my husband's girlfriend. She dressed carefully for the occasion. Tailored, expensive, confident in the particular way that comes from never having been wrong in a room before. She sat beside my husband with her hand resting lightly on his forearm, and watched me walk in like she was waiting to find out which kind of woman I'd turn out to be. The crying kind, that's what they expected. Or the angry kind, the kind who throws things, raises her voice, gives everyone present a story to tell later. My mother-in-law settled herself at the head of the table and looked at me with barely contained contempt. "My husband always said the women who last in this family are the ones with real drive," she said. "There's nothing wrong with being a homebody. Some women are built for that. It's just important to know which one you are." She gestured toward my husband's girlfriend with one ringed hand. "She understands the pressures he works under. She operates in the same world." My husband's girlfriend nodded slowly, the way people do when they want to seem thoughtful, while actually just agreeing with whoever holds the most power in the room. "The paperwork is straightforward," she said to me, with a warmth that didn't touch her eyes at all. "We've had our firm review everything very carefully. There's genuinely no reason this has to get messy." I looked at her. I thought about the patent number on her laptop screen. I thought about the amendment she drafted. I thought about the fact that she had no idea, none, that the name on the original inventor disclosure was mine. "I'm sure you're right," I said pleasantly. "I appreciate you being so thoughtful about all of this." She smiled. My husband smiled. My mother-in-law reached for the wine. My brother-in-law was the only one at that table who didn't fully relax. He'd been watching me since I sat down with an expression I couldn't quite place. Not guilt, exactly, but something adjacent to it. Like he was waiting for a reaction I kept not giving him. I gave him nothing. I ate the dinner. I left before dessert with a headache I didn't actually have. Walking to my car through the cold November air, I was thinking about a specific clause in patent law regarding co-inventor rights. I was thinking about what it means, legally, when someone files a false sole inventorship declaration on a patent where they are not, in fact, the sole inventor. I was thinking about how that particular action doesn't just create a civil dispute. It creates a federal record. The call from the lead researcher at my husband's company came 11 days before the transfer was scheduled to close. She'd been with the company since its second year. She was meticulous and methodical, and she'd spent 3 years working directly with the foundational TX9 mechanism, which meant she understood the technical documentation better than anyone there, including better than my husband. She called on a Sunday afternoon, which told me right away she wasn't calling from the office. "I've been going through the original license agreement," she said. "The one from before the company was even incorporated. I pulled it because something in the new amendment didn't track technically. The claim language was inconsistent, and I found the inventor disclosure." A pause. "I found your name." I let a moment pass. "How long have you known?" 3 days. I needed to think it through first. Another pause. "He's filing a sole inventorship transfer declaration in 10 days. If it goes through, the original patent gets reassigned under his name alone. The license gets restructured. The $38 million from the sale gets distributed in a way that cuts the original inventors out completely. All 3 of you." "I know. Are you going to let that happen?" I was sitting at my desk, looking at 2 weeks' worth of documentation I'd been quietly compiling. "No," I said. "But I need one thing from you, the board meeting minutes from the last 2 quarters. All of them." She didn't hesitate. "You'll have them by morning." I let my husband believe he'd already won for 8 more days. I went to the one meeting he asked me to attend. A final courtesy mediation his attorney had arranged, clearly designed to walk me through a settlement offer built on the assumption that I had no idea what I'd actually be signing away. I wore jeans. I brought a canvas tote bag. I let his attorney talk for 20 minutes about the complexity of IP asset structures and the significant legal costs of contesting a finalized transfer, and I nodded in the places where nodding seemed appropriate. Then his attorney slid a document across the table. A spousal acknowledgement form, a statement confirming I had no claim to any of the company's intellectual property assets. "This just formalizes what we both already know," my husband said. He wasn't looking at me when he said it. He was checking something on his phone. "You were never involved in the company. This is just paperwork." I looked at the document. Then I reached into my bag and placed a single folder on the table. "Before I sign anything," I said, keeping my voice very quiet, "I need you to sign something first, just for my peace of mind." My husband looked up from his phone. The document I'd placed in front of him was a standard federal inventor declaration form. It confirmed that the signatory was, to the best of their knowledge, the accurately listed inventor on all patents owned or controlled by the company. "This is an emotional request, not a legal one," I said. "I just need to hear you say it clearly, on paper, that everything you've built is truly yours, that no one else's name belongs on those patents, that there's nothing you've overlooked." I let my voice drop just slightly. "Just sign it and confirm you're telling the truth. Then I'll sign your settlement right now, and you'll never have to see me again." His attorney reached for the form immediately. "My client has no obligation to." "Let me see it," my husband said. He scanned it for maybe 15 seconds. Then he picked up the heavy pen on the table, one of those expensive things people buy when they want signing documents to feel significant. And he signed his name at the bottom of a federal declaration stating that he was the sole controlling inventor of all technology underlying his company's patent portfolio. His attorney said his name like a warning. My husband waved him off. "It's a form," he said. "She needs closure." He pushed it back across the table. "There, are we done?" I folded the document and placed it in my bag. Almost, I said. The patent tribunal hearing was convened because the lead researcher had filed a formal inventorship dispute, her legal right as someone with direct technical knowledge of the original invention. My name appeared on the dispute filing as a co-inventor of record. My husband found out 2 days before the hearing. I know because he called me 9 times in under an hour. I didn't answer any of them. The hearing room was smaller than a courtroom, but carried the same specific weight, the sense that whatever happened inside would be documented, permanent, and consequential. My husband sat with his attorney at one table. I sat alone at the other. His girlfriend was in the gallery with her face arranged in professional neutrality that cracked around the edges when she saw that I wasn't crying. My mother-in-law was there too, seated in the front row with her hands folded in her lap, watching me with the particular expression she'd perfected over 6 years, patient, pitying, certain. My husband's attorney moved immediately to have my appearance dismissed. No co-counsel, no filed brief, no formal legal representation on record. With respect to the examiner, he said, and I've rarely heard that phrase deployed with less actual respect. The individual at the opposing table is the petitioner's estranged wife. She has no documented professional connection to the intellectual property at issue. She has no legal training. She works from home on freelance administrative projects. She is not a patent attorney. She is not an inventor of record on any documentation this tribunal has before it. She is not, in any professionally meaningful sense, a participant in this proceeding. He smiled at that last line. My husband smiled behind him. The examiner didn't smile. He was reading the case file. He turned to page 3 and was quiet for a moment that stretched long enough for the room to shift in its collective posture. Then he looked up and said, "Counselor, did you read the full inventor disclosure on this patent before you filed this transfer?" Silence. The original inventor disclosure on the TX9 mechanism patent lists 3, examiner continued, in exactly the same tone. The name at position 2 on that disclosure matches the name of the individual currently seated at the respondent's table. He looked at me over his glasses. Who holds an active license as a registered patent attorney in the state of Texas. Bar number on record. 7 years of documented IP work under her professional designation. He set the file down carefully. I'd like to understand, counselor, why you represented to this tribunal that the respondent has no professional connection to the intellectual property at issue. My husband's attorney said nothing. His mouth moved. Nothing came out. I turned and looked at my husband. He had gone the color people go when something they believed was solid ground turns out to be open air beneath their feet. His jaw moved, but nothing was attached to it. In the gallery, his girlfriend had stopped performing neutrality entirely. She was staring at me with an expression I recognized. Not anger, not contempt, but the specific shock of someone who realizes they have profoundly misread a situation from the very beginning. I reached into my bag and placed the Federal Inventor Declaration on the table in front of the examiner. I'd also like to submit this for the record, I said. It's a federal declaration signed by the petitioner 9 days ago, stating that he is the sole controlling inventor of all technology underlying his company's patent portfolio. Given that my name appears on page 3 of the original inventor disclosure, this document constitutes a false declaration made to the federal patent system. I paused. A false inventor declaration filed in connection with a patent transfer isn't a civil matter. It's a federal offense, and the transfer itself, structured using legal documentation drafted by an attorney with an undisclosed personal conflict of interest in the outcome. I looked briefly toward the gallery, would be subject to a separate review by the relevant bar authority. My brother-in-law stood up so suddenly that his chair scraped across the floor. He looked at my husband for one long second with an expression that held many things at once: anger, calculation, and the very specific fear of a man who has signed documents that are now evidence in a federal proceeding. Then he walked out before the examiner had finished writing. My mother-in-law sat completely still. She had come to watch me be dismissed. She was watching, instead, her son's company, her son's freedom, and 6 years of carefully constructed superiority come apart in 15 minutes. In a room full of federal witnesses. She looked at me once. Just once. And for just a moment, the contempt was gone. What replaced it was harder to name. Something like the belated recognition that she had spent 6 years looking directly at me without ever once actually seeing me. I held her gaze. I let her look as long as she needed to. The transfer was frozen pending investigation. The false declaration triggered a formal review. The lead researcher's inventorship dispute moved forward with full documentation. My husband's girlfriend's firm placed her on administrative leave within the week. Submitting legal documentation in a matter where you have an undisclosed personal relationship with a party is a significant bar ethics violation, and that process has its own timeline. My brother-in-law hired his own attorney before the day was over. The divorce was filed by me, not by him. The settlement reflected the full scope of what I was actually owed, not just as a spouse, but as an inventor whose name had always belonged in the record. The lead researcher texted me the night after the hearing. It said, "I'm glad I called you." I sat with that for a long time. Because the truth is, I almost let it happen. There were weeks when I thought about just taking the settlement, letting the transfer go through, walking away from a situation that had already cost me so much of myself. It would have been easier, less documented, less permanent. But there's something that happens when you watch someone try to erase you. It clarifies things very quickly. Not just the financial reality of what's being taken, the deeper thing. The insistence that your value is whatever someone else decides it is. That what you know, what you've built, what you've contributed only counts if the right person confirms it. My name was on that patent. It had been there for years. It didn't need anyone's permission to exist. Neither did I. If you've ever had someone try to quietly rewrite your history while you were still living it, drop something in the comments. And if this story meant something to you, share it with someone who needs to remember that the quietest person in the room is not always the least dangerous one.